we have invited a panel of legal professionals from a diverse background to discuss how in-house lawyers can make use of different dispute resolution options to help our companies to resolve cross-border disputes. These include Mr. P.S. Howe, Partner, Charles G. and Kenneth Sid, Mr. Billy Ng, Director, LegalMap Limited, Dr. Thomas So, Chairman, eBram International Online Dispute Resolution Center Limited, and our moderator, Ms. Irina Chan, Vice President, KKR Asia Limited. Please join me in welcoming our panelists to the stage.
Hi, everyone. Thank you for coming to this session today about the topic is when there are no borders, dispute resolution across jurisdictions. Now, to my immediate left, we have Dr. Thomas So, who's as everyone knows, as the past president of the Law Society of Hong Kong, and he's also the chairman of eBram International Online Dispute Resolution Center Limited. And to his left, we have Mr. P.S. Howe, who is a partner at Charles Chu and Kenneth Sid. And to his left, we have Mr. Billy Ng, who's the director of LegalMap Limited. Today's topic feels like a pretty broad topic, with a lot of potential issues and perhaps questions from the audience. But perhaps I'll start with the eBram International Online Dispute Resolution Center Limited. Now, for us in-house lawyers who may or may not have exposure to disputes or dispute risk management, this seems like a very, very innovative way to deal with disputes. Or as I have learned from the website, the official website of eBram, actually there's a range of services, including mediation, some litigation type dispute resolution services. So I would like to invite Dr. So to actually introduce and share with us what the eBram platform is about and how it's what prompted him to start this very innovative legal tech service.
Thank you. Can I go over there? Oh, yes. Thank you, Irina. Good morning, ladies and gentlemen. Thank you to the Law Society for organizing this event, which I have actually attended continuously over the years. And this time, thank you for giving me the opportunity to talk about eBram. Many of you probably may or may not know, eBram, in fact, is one of, if you can use that term, subsidiary of the Law Society of Hong Kong, because Law Society of Hong Kong is one of the founding members of eBram, and Law Society has been very supportive to eBram's work, and hence today, this year, particularly because all the products that eBram have spent time to develop have started to roll out. So we see today as a very good opportunity for eBram to introduce to all of you what we can offer to you all. Now, although the name of eBram suggested that we are focusing primarily on online dispute resolution, but in fact, it is not just that. eBram is a law tech company, and we focus on all type of use of technology service to promote and take legal services and dispute resolution services to the next level. I have a set of PowerPoint that I will take you through. And by the end of the session, if you have time, we have a booth outside where you can take time to try out some of our platform and some of our product and try it out for yourself. Because being members of the Law Society, in fact, we are relatives. So, we can now move to the second slide. Well, the need for effective avenues for making business, not just resolving disputes, as well as resolving disputes that may arise with robust and trustworthy resolution mechanism has never been more critical before. So we think that the avenue that we can choose to do all this, doing business and resolving dispute, can be done online. As part of today's session, I will provide some background on eBRAM, our milestone thus far, and our service and our offerings. As I introduced just now, with the support of the Law Society of Hong Kong, and also the Department of Justice, and the Hong Kong Bar Association, as well as the Asian Academy of International Law, eBRAM was founded as an independent and non-governmental, non-profit-making organization, providing services as an online deal-making and dispute resolution institute. The motivation for establishing this institute was primarily to promote the use of technology in deal-making and in alternative dispute resolution to improve access to justice. So, because we are non-profit making, the fee that we generated do not go into my pocket, for example, or the Law Society's pocket, but it will be put into use into eBRAM's funding for the purpose of pushing further down the line the provision and development of technology to assist legal services and dispute resolution services. So to achieve this, eBRAM was set up to be part of an ODR, Online Dispute Resolution Institute, and part law tech startup with its own technology development capabilities. This atypical combination places eBRAM uniquely in the law tech and dispute resolution community, and perfectly in a time of rapid digital expansion. eBRAM was established in 2018. In the past 2.5 years, eBRAM has developed 4 ODR platforms and the Hong Kong Legal Cloud. We will also soon be launching a deal-making portal, which will be primarily for businesses and their transactional lawyers like yourself. So before I talk about ODR, I would like to touch upon the deal-making portal first. The deal-making platform is an all-inclusive e-commerce portal that facilitates cross-border transactions using advanced technologies to help you identify and collaborate with potential business partners. Of course, doing business online is not a new thing, and businesses, in fact, have been conducted one way or the other online. And this has happened for the past 25 years. But be that as it may, there is still very much to be desired and improved in doing business or resolving disputes online in a well-structured manner. And indeed, the speed of doing business online has only grown more haphazard. Hence, we think that with the deal-making portal, we can make doing business online a safer, more certain environment, which will benefit, in particular, cross-border trade for particularly SME and MSME. The deal-making platform has a number of features. It has an e-directory system, and it also includes deal flow management. The deal flow management helps businesses track deal progress, create meetings, upload and download documents for business negotiation and e-signing. Our deal flow management system also helps users monitor the progress of a deal with indicators. Users can directly negotiate with their deals online through the video conferencing system. User verification and credibility check is also an important feature of this deal-making portal. As part of this, the deal-making portal facilitates applications for LEI, that is, Legal Entity Identifier, a global unique identification for legal entities, enabling other users to help identify entities and increase traceability and security in transactions. It allows individuals or businesses to determine if they are dealing with recognized business entities. This eKYC function during registration for the deal-making portal also provides a second layer of verification as to the identity of the business entity. As I mentioned before, the deal-making platform will help with cross-border trading, and cross-border trading has definitely been conducted at never before seen volumes, thanks to the internet. But because of the overload, it is more often than not in the case of cross-border trade that dispute resolution mechanisms become much more an afterthought. Yet, cross-border disputes can arise in various contexts, from commercial, technology, and IP in international trade. And indeed, many cross-border disputes do arise, but the parties find that there is not much they can do about it. When these disputes do arise, more often than not, the businesses involved find themselves in a mess of legal issues, including much uncertainty as to where to even begin seeking claims against the counterparty, and much hassle over figuring out which laws would apply and be useful. EBRAM serves as a groundbreaking solution to bridge the gap between parties to provide an accessible and efficient and a cost-effective resolution. Leveraging on technology, we have therefore developed online dispute resolution, ODR, platforms, and where appropriate, we have applied the latest technologies such as blockchain and AI to the platform to facilitate the resolution of disputes. This allows EBRAM's ODR system to be swift, affordable, and convenient. It is noteworthy that EBRAM is one of 7 qualified institutions in Hong Kong eligible to apply to mainland Chinese courts for interim measures in aid of Hong Kong-seated arbitral proceedings under the arrangement concerning mutual assistance in court, ordered interim measures in aid of arbitral proceedings by the courts of the mainland, and of the Hong Kong Special Administrative Region, where claims made on behalf of clients involve the need to secure assets in the mainland, and EBRAM administered Hong Kong-seated arbitration could be a potential avenue for achieving this objective. There were a number of objectives when designing the ODR system. It was meant to be a set of tools for arbitration and mediation proceedings that were secured by design and had bank-grade encryption capabilities enabled. The encryption and secure designs are intended to satisfy the confidentiality requirements under law for arbitration and mediation proceedings. One of the key advantages of EBRAM's ODR platform is accessibility. Making the system convenient and affordable is key to improving accessibility. Parties involved in the dispute can access the platform from anywhere in the world, eliminating the need for costly travel and enabling individuals and businesses to resolve their conflicts in a timely and cost-effective manner. It is, of course, not sufficient for the ODR platform to exist alone without legal backing and without institutional support. That is why the ODR platform is based on a range of dispute resolution mechanisms, including negotiation, mediation, arbitration, the last 2 of which operate within the same framework under the Mediation Ordinance and the Arbitration Ordinance in Hong Kong. These methods provide parties with flexibility and control over the outcome of their disputes, allowing for tailored solutions that meet their specific needs. EBRAM's role as an institution ensures that the rules and procedures to support mediation and arbitration are complementary to the ODR platform. In this regard, EBRAM has 4 sets of rules to cover different usage scenarios. So why use EBRAM's rules? EBRAM's ODR platform does not require the use of EBRAM rules. However, parties in dispute enjoy advantages when they agree to use EBRAM rules alongside EBRAM's ODR platform. Administrative fees of EBRAM under EBRAM rules are generally more economical compared with many other institutions. Moreover, the vast majority, and in some cases all, of the cost of using the ODR platform is included already in the administration fee. In addition, EBRAM is listed as one of 4 ODR providers under the APAC Collaborative Framework for Online Dispute Resolution of Cross-Border Business-to-Business Disputes. Indeed, it is the first and only such ODR provider from Hong Kong. Pursuant to the model procedural rules under the APAC Collaborative Framework, EBRAM launched its EBRAM APAC rules, showcasing its determination in providing a fast and affordable resort to resolving commercial disputes among the APAC economies, in particular for the MSMEs. If you are interested in using the EBRAM rules, it would be a good idea to insert a dispute resolution clause into parties' contracts in advance, which specifies using our rules and our institution for administration. Here on the screen, there is a QR code to our web page, which sets out our model clauses for the dispute resolution clauses, if you're interested. Here, let's look at the ODR platform. ODR is not about replacing mediators or arbitrators with technology like artificial intelligence or automated prompting. We distinguish ODR from automated decision-making because, as fast-growing as artificial intelligence technologies are at the moment, we are conscious that there is still some way to go before artificial intelligence technology is mature enough to make automated decisions, or would be flexible and intelligent enough to conduct mediation on its own. Indeed, EBRAM currently incorporates aspects of artificial intelligence, specifically machine learning translation, to make it easier for parties with different language backgrounds to communicate. Indeed, ODR is about helping parties to manage their disputes with an end-to-end toolkit of technologies. The idea of ODR is to move the entire process from commencing an arbitration or mediation to the settlement of the disputes online. There are multiple compelling reasons for doing so. Parties can share relevant information and documents to the arbitrator or mediator and the counterparty. The advantage of using the document sharing and case file management function of the ODR platform over transferring the information by email is that email sizes with large attachments can often be restrictive. Even if your email server is capable of sending larger email attachments, there is also a real risk that the email recipient's inbox may not accept large attachments, resulting in bounce-back emails and failed transmissions. The document exchange feature on the ODR platform avoids this by providing large amount of storage space for parties and the mediator to utilize. Emails also take time to manage, no matter whether you are a lawyer who has to handle multiple cases simultaneously, or if you are a business person whose email relating to your dispute would very likely get mixed up with other emails. It can be cumbersome and time-consuming to isolate the emails, documents, and information relating to the matter. However, if the parties utilize the documents exchange and sharing function of EBRAM's ODR platform, the information will already be in one place, right from the beginning. Parties will also be able to very quickly see consolidated information about their case. In the past, lawyers may have to craft their own information sheets about their case, but with the ODR platform, it is now all laid out clearly. This includes information relating to the parties, the specifics of the arbitration in question, list and calendar views of the procedural timetable. EBRAM's ODR platform also integrates video conferencing directly onto the platform, so it would not be necessary for the parties to make extra logistical arrangements. Moreover, the video conferencing capability was designed specifically to complement the ODR platform. So security of the platform has been of top priority, which contrasts with commercial video conferencing software offered for general use. The platform includes real-time machine transcription and translation capabilities. Let's now take a look at the machine transcription feature.
My name is Mei Tai, and I have been appointed by eBram to serve as a neutral arbitrator to hear and decide this matter. I, not eBram, will decide the award. Could the parties or their representatives please introduce themselves?
Yes, thank you. My name is Robert Roeder, and I represent the claimant in these proceedings.
And my name is Freeman Europe, and I represent the rest party.
I think the print is a bit too small, so if you're interested, you can try it out again at the booth outside when you have time. So about e-signing, if the mediation or arbitration is successful, it is necessary to draft and sign the settlement agreement as soon as possible to secure the new consensus. With the integrated electronic signing feature, the mediator and the parties can swiftly upload a settlement agreement onto the platform to be signed, even if the parties remain in remote locations. The e-signing can be done on any computing device with an internet connection. And if the parties wish to have a more intuitive signing experience, they can also sign on their mobile phone by scanning a dedicated QR code. One point about eBram's e-signature service is that eBram's e-signatures do not just allow you to conveniently sign on whichever device you may have, but more importantly, and behind the scenes, the system also generates a unique marker of your document that is then stored on a blockchain, which we host. Once that is created and stored on the blockchain, the document cannot be tampered with. Our system helps the parties verify the integrity and keep an audit trail of signed documents. This is something that traditional wet ink signatures or even digital images of signatures passed on documents cannot do. I encourage you to explore eBram further to experience its benefits firsthand at our booth in the foyer outside. Then let's talk about Legal Cloud. Hong Kong Legal Cloud is another service alongside our ODR platform that provides the ability to store and exchange documents securely online. To conduct legal research with our partnership with LexisNexis and to conduct quick machine translation of documents through our partnership with RWS. This toolkit was developed to aid lawyers in their day-to-day work, especially lawyers from small and medium-sized law firms and barristers who may historically have more difficulty accessing to the latest law tech. With a subsidy from the Department of Justice, we have been able to provide this service for free and will continue to be free for the next year or so for the Hong Kong legal community. So for those who have not yet registered, please do so after this session. All of these platforms are secured by design because as a legal institution itself, eBram appreciates the importance of confidentiality. And in terms of data privacy, eBram complies with not just one, but 3 sets of data laws, namely the Personal Data Privacy Ordinance in Hong Kong, the Personal Information Protection Law in the mainland, and also the General Data Protection Regulation from the EU. You can see that we are very serious about ensuring data privacy. Data itself is also secured using bank-grade encryption, and we have put our system to test by external security consultants who have conducted penetration tests and security audits, and we do that very regularly every year. eBram represents a significant leap forward in the field of dispute resolution and in deal-making in the digital age. Its accessibility, security, user-friendliness makes it an indispensable tool for businesses and lawyers worldwide. By embracing this innovative platform, we can navigate the complexities of the modern business landscape with ease and confidence. I urge you all to embrace this new approach and consider adopting our deal-making platform, ODR platform, and our law tech for any future needs. Thank you for listening, and me and my colleagues from EBRAM are here to answer any questions that you may have after this session. Thank you.
Thank you so much, Dr. So. That was incredibly interesting and impressive, because it really rewrote my impression that dispute resolution is the traditional litigation with lots and lots of bundles. And, you know, when I watched the demonstration of machine learning translation, that was incredibly fascinating. I mean, in the past, we would have to engage someone, you know, a professional translator to sit in and live translate everything. And that certainly, you know, this platform and this technology certainly saves a lot of costs and makes dispute resolution a lot more time as well as cost efficient for the parties. So I actually have one question for Dr. So, if you don't mind sharing with us. In building something so innovative for such a traditional sector of the industry, you know, dispute resolution, what was the perhaps top of the mind challenge that you have encountered in leading this effort?
Thank you, Irina. This is a very good question. And again, I would like to say thank you to the Law Society, because obviously, and also people like Nick Chan, I mean, who has been instrumental in helping EBRAM to grow from its birth, right? And it is not easy, okay? And I'm looking at it, and I'm always using this example to share with people, encouraging people to use technology, meaning you are asking people to change how they do things, okay, traditionally. I was in fact in an arbitration last week as an arbitrator, and lawyers and barristers were still flipping through their bundles, and I was suggesting, oh, don't you, you're exactly right. They were using consecutive translator, and so we had to sit there and wait for the translation to finish, then the cross-examination continue. And I was asking them, do you not know that, you know, about EBRAM's product? And they say, what is EBRAM? So our thought, you know, that is the reason why we need to introduce this more to all of you. Now, the example that I was saying is, many of you probably were not born the age that I was born, right? Okay. In the 80s, I still remember at the end of every month, we were eager to check on how much we get paid. Okay, so on the 28th of every month, I remember there would be queues at the counter of big banks in Central, because we used to have this book, red booklet, okay, where you go and kind of clock in. We call it 打保, okay, to check on the salary, how much you get every month. And there's queues, long queues. And you still have to do every transaction you want to get cash off counter. That's a big queue. Okay. Then there is a creation of this ATM machine, if you remember, the ATM machine. And at first, people feel, oh, you know, is that real? You know, you go to the machine, you click in, and then money transfer. But then, you know, in the old days, you feel like getting something more tangible. You know, you have a bank slip confirming the transaction, so that is something real, tangible. And it takes time for people to change the way how they do things. And the ATM machine then changed from a cash point into a machine that you can actually do transaction. Okay. And now, 40 years, not that many people use ATM machine anymore, because you can now do everything online. So it takes time for people to change the mindset and the way how to do things. And how do we encourage that. I think, first, I think the product really need to be user-friendly and let the users know and experience that this is something even better than how they have been doing things. That is first. And second, I think we need policy from the government to help us push this. Plus, users like Law Society, Bar Association members give us a chance, use our product, feedback to us, let us hear what you think about the product, and we improve. I think that is at the moment what we are doing, and over the past 2.5 years, we have received a lot of support, a lot of input from members, from users, that we really treasure, and we hope that we can have all of you, okay, try on our eBrand products, because I just introduced you, it's free, okay, for members, and let us know how you feel, whether there is anything that you think we should do better, because you guys are the users. You know, sometimes we have to listen to you, because as I said, a product will not be successful if it is not user-friendly. So we will listen to you, and we will improve our product and our services to meet your expectation. And that is, at the moment, if you ask me, you know, the challenge of eBrand. And I would hope that people around this room will use our product and support our direction in trying to introduce more technology service and technology product to help legal services and also dispute resolution services to excel.
I completely agree. I mean, I, for one, would be very keen to try that product. It looks like a very helpful product for in-house counsels, in particular in managing, you know, the litigation or dispute resolution process and costs. So thank you again, Dr. So, for your sharing today on eBrand. So as we all might appreciate, of course, when the problem arises, it's very important to fix it with the right method. But as in-house lawyers, we may always be more interested in the stage before the problem actually arises. We'd like to prevent it. We'd like to manage the risk. So I know that PS today has something to share about how to effectively prevent or manage the risk of dispute resolution. So may I please invite PS to share with us. Thank you.
Good morning, fellow professionals. First of all, I wish to thank the Law Society of Hong Kong in organizing this event, as well as our sponsor to make this event happen. I also want to extend my thanks to Dr. So in his excellent presentation of the eBrand platform. I must confess, Dr. So, that I'm still an ATM user, as well as a court user, which bring a lot of hard copy bundle to the court. In fact, I'm a big client of a moving company. Not that we need to move office, but from time to time we need to move hundreds of boxes of papers to the court for the hearings. So I only hope that one day the eBrand technology can be extended to court users. In fact, thanks to your relentless efforts, as well as those, including Nick Chan, in promoting the eBrand platform, I've seen an increasing trend of companies, including tech companies who are familiar with the eBrand technology, to include in the dispute resolution course for eBrand arbitration rules to be incorporated. For this topic about dispute resolution, even though I myself am a dispute resolution lawyer, my first and foremost advice to every client is please prevent dispute risk if possible, or otherwise manage it. Dispute is not only costly. The most significant downside of engaging in dispute is that it is time-consuming and counterproductive to the client's usual business. Much time would have to be spent by the client as well as the in-house counsel and the legal team in retrieval of historical records, giving very detailed instructions to your lawyers, and also to rebut the other side evidence and case. So much time would have to be spent in locating relevant documents out of tens of thousands of emails and documents to rebut one point. And these times could otherwise have been spent for more productive business. And that's why my first and foremost advice to each client is please prevent litigation or dispute at all costs first. In terms of dispute risk prevention, one of the most important stage would undoubtedly be at the contract negotiation stage. Many of us, as lawyers and in-house counsel, would be familiar with the allocation of risks in contractual contexts, such as limitation of liability, warranties, how wide or how restricted warranties should be given, and all sorts of security given in ensuring the performance of contract. For instance, there might be guarantees, there might be share charge in the underlying project companies. There could be insurance bond or irrevocable power of attorney for the enforcement process to happen in case of default. Many parties would design appropriate corporate structure to align their commercial objectives in ring-fencing the dispute risk or to facilitate enforcement process. I must also stress the importance of conducting effective due diligence of the target company as well as the counterparty in understanding the risks involved prior to the conclusion of contract. In cross-border contexts, it is also important to engage local counsel and sometimes specialist counsel to advise on the contract before conclusion. But it is, however, very easy to say all this than it being done. The main reason I've always encountered is that at contract negotiation stage, all the parties are in good, usually, but not always, in good commercial terms. And for the sake of speedy conclusion of the deal, they might be willing to agree to terms which are not clearly defined in accordance with their intention. This is in particular in the context of ongoing obligations after the conclusion of a contract. For example, ongoing obligation in a business venture, and sometimes the terms are not clearly defined by reference to specific benchmark. Some of the reason is probably due to the need for a speedy conclusion of the deal, and other reason could be at the time of the conclusion of the contract, there might not be sufficient knowledge and time to designate the benchmark performance. In that case, and usually the client might say, okay, don't worry, we will manage, we negotiate when it comes to it. and the parties are very friendly, we don't have disputes. But in reality, disputes will easily arise when the relationship turns sour. And when that happens, the arbitrators and the courts who adjudicate the case many years after the conclusion of the contract, they can only interpret the contractual clause in accordance with the usual contractual principle, which might not be the intention of one party at a time. In cross-border context, the parties may understand the contract terms from their own domestic context, and the difference in the understanding can lead to disputes. So one takeaway from this is try the best to define clearly the contractual terms. Unless there is no choice, try to define specific benchmark as to ongoing obligations. This will effectively prevent and manage the litigation risk. In anticipation of the reality that dispute may arise, parties should pay special attention to the choice of law course and dispute resolution course, which is critical in managing the litigation risk. Unfavorable choice of law or jurisdiction can adversely impact a party's ability to seek legal recourse. For example, if you are a minority in a joint venture, you may wish to go for a jurisdiction which provides for remedies such as unfair prejudice or derivative action. Hong Kong law is one of those jurisdictions which provides this remedy. And one thing to bear in mind in selecting choice of law is the consistency between the governing law and the jurisdiction clause. For example, if a dispute is to be resolved in Hong Kong, generally speaking, it would be sensible to choose Hong Kong laws unless there is good reason not to do so. Inconsistent governing law and jurisdiction clause can increase the time and cost of a dispute due to the need to present expert evidence in foreign laws. In terms of dispute resolution clause, the obvious choice to make is between arbitration and litigation. And it depends on a number of factors which most of us are familiar, include whether there is a need of confidentiality, whether there is a need of speedy resolution, and how the dispute resolution process can facilitate enforcement objective, and also the need of feasibility of fee arrangement. Apart from the typical arbitration and litigation clause, you may also consider so-called multi-tier dispute resolution clause or escalation clause, such as the parties are first to mediate or to negotiation first as a precondition to arbitration. In terms of the form of dispute resolution, obviously the ERAM is and should be one of the good choice. I would also want to advocate Hong Kong as one of the most popular dispute resolution center in the world. Hong Kong is constantly ranked amongst the world's top 3 as the most preferred seat for arbitration. And Hong Kong has our arbitration ordinance kept in line with the international standards. Recent amendments to our arbitration ordinance includes to allow flexible third-party funding, and also since last December, we have introduced the outcome-related fee structure arrangement regime in arbitration. Arbitral awards made in Hong Kong are enforceable in over 170 contracting parties under the New York Convention. And the unique advantage of Hong Kong arbitration is its connection with the mainland China. To date, Hong Kong has signed 9 arrangements of mutual legal assistance in civil and commercial matters with the mainland. These arrangements are broadly categorized into 3 areas, namely procedural assistance, arbitration-related assistance, and reciprocal recognition and enforcement jurisdiction. Hong Kong is also the only common law jurisdiction outside the mainland which enjoy the convenience and privilege of interim measures arrangement in the mainland, so that parties to arbitration seats in Hong Kong and administered by designated arbitral institutions can apply to the mainland courts for interim measures. These measures include preservation of properties, evidence, and conduct. And according to the figures of the DOJ, there are, as of the 31st of April 2023, the Hong Kong arbitral institutions have made more than 93 applications to the mainland courts. The majority of the applications, being 88 of them, involve the preservation of assets. So far, the mainland courts have granted 63 court orders to preserve assets of a total worth of RMB 15 billion. The take away from this is Hong Kong, and I would recommend all of you, if you so happen to have the need to draft dispute resolution clause, to consider Hong Kong arbitration clause as part of the dispute resolution clause. So this is the conclusion of my speech. Thank you.
Thank you so much, P.S. Indeed, it is so important to place enough emphasis on the sort of preparatory stage of, contracts, commercial agreements, to make sure the parties actually do reach an agreement and there's enough certainty in the documentation that's settled. Now, I'd like to ask Billy a few questions as well. And if you don't mind, actually, I have a very basic question. Would you mind sharing with us what LegalMap does?
Actually, when I was asked to do this talk, they said it will be very brief. Someone will ask questions, and then we just casually answer. And then you have Thomas, the big slide, and then PS with 10 of pages. I was like trapped. Okay, but that's fine. Because I know we have a dispute here, and the topic is about dispute without borders. What's the dispute here? Because I'm your obstacle to your lunch. I know the feeling. As the last speaker and before the lunch, you want me to just finish it. And I'm very surprised because when I was still an in-house counsel, I used to come here every year and sit at the back to count who is sleeping. But not too many of you are sleeping. Very, very rare. I mean, this is maybe because this is the first one post-COVID, and we have the live event. And it's just great to see so many faces. Finally, I don't go out a lot. I usually stay in my home. And then the other thing which is so different from in the past is the technology advance. Besides the e-brand is we have the screen. Before that, I can't see myself. So I thought I look okay. And I see myself is really fat. People say you're fatter, 10 pounds on the screen. I think, oh, how many cameras? I'm like 50 pounds fatter than myself. So for those on the Zoom, I'm actually not that fat. And then for the e-brand, I have one question before I go on, is since now we have the deal making and we have other functions, will the name maybe change soon because we are no longer just dispute resolutions?
You're absolutely right. Thank you, Billy. You're absolutely right. It may well be an agenda item next time round for EBRAM to consider whether we should add in the deal making as part of our name.
Do you still take investment? Because it will be a unicorn very soon, so
Well-
maybe we can chip in some money.
Well, let's look at it. Yes, welcome. Well, can I have your name card?
No, you have my mobile, and we can see each other at the ATM machine
Yeah.
as well.
Okay.
Although we don't get a big paycheck as Thomas do in the past. But back to your questions. What was your question? Still have.
What is legal map?
Oh, yeah. We do
Thank
deal
you.
making. That's why the deal making part is really attractive. In the recent example, actually, we tried to convince the counterparty to use EBRAM, and then they refused. Actual example, just a few months ago, because they said, I don't know about this, and this is from Hong Kong, etc. It's an international thing. And then they insist on using Google Drive. I said, what? That's not safe. Everyone can have edit rights, and then people will share it. And they said, no, Google is safe. EBRAM is safer. Prove me. I can't prove you. Endorse it? No. Can you sign indemnity? Of course I won't. So that was the end of the conversation, and eventually everything on the Google Drive, I just downloaded myself, obviously, very happy. And that's wrong. So I think if with more education and then promotion, I'm sure we can start with the contract, and then since people get into the contract, then when they have dispute, they just come back. In between, you can do a lot of other stuff like alerts and things like that. I think that will be the real flow for us as I was an in-house counsel for many years as well. We start with the contract, and as PS said, we may not have a choice. We just need to take the template. You know, people will say, this is a template we stole from Clifford Chance. It's perfect. So how do you argue? So there is a clause, ICC arbitration, is very expensive. No, this is from Clifford Chance, it must be good. So those are the difficulty we face sometimes when we get to the border place, when we are already very tired. We want to see our family. It's like in war in Iraq. You want to see your family, and there are still border places to negotiate. Okay, fine, whatever law, you know, the law of the mass, fine. I'll just sign it as long as you do the closing. So if we want to get it in, I think just give us more benefit. You know, sign up for the EBRAM clause, and then you get some free
Yes.
ice cream, something like that.
Well, I think at the moment, if you have a case that use EBRAM, I think there is a discount if the case is filed before the end of this year. So, yes, there will be a discount. But then back to your question, I think that at the end of the day, some people take, they are entitled to take certain view about Hong Kong and about what we do and about our legal industry and our dispute resolution industry. But at the end of the day, I think seeing and experiencing is believing. So, so it would be up to us. I think many of you sitting around here work for foreign companies, international companies, and you have every right and have every opportunity to speak out and explain to your boss or people around the world that Hong Kong, what your experience is about Hong Kong legal services and about our dispute resolution services. And if you try out EBRAM, if you think that it is good, you know, you would be entitled to speak out. And then, after all, customers have a choice, you know. Seeing and experiencing is believing. So if you use us, if you use a product, it is good. Compared with other institutions, I wouldn't say other institutions are bad, necessarily bad, because different institutions, different model serve different sectors and different types of cases. So, all I say is, you know, seeing and experiencing is believing. So try it out first, and then you can talk about your experience about using EBRAM.
Yeah, it's amazing for you and Nick to do this startup because of your, you know, you're not young, but great job. I mean, you know, Nick is a very busy person, and Thomas too, and this is just unique. You don't see that in the legal world, and also it must be supported. I think we should put in a lot more contracts so that later,
Thank you, Billy.
later things
Thank
will
you,
flow
thank you.
back. And back to what Pierre said, I like his disclaimer. As a litigator, when you come to him, he said, no, avoid the legal things at all costs. You know, that tells everything, because he's very expensive. So later on, you can't complain about the bill. That's right, right? And so, no, he is not that at all. Very reasonably priced. But what I want to say is in international elements disputes without borders, in fact, is not that different. I fly around the world. In Middle East, one time, I was there trying to solve a case, get into the car, and that guy, the local guy who actually take me to see the local lawyers, he said, okay, let's solve it in your way. If not, then I'll get my pistol. And then I opened that box, and there's really a pistol inside. Yeah, and actually, it's not that different, because at the end, it's just a joke. It was not real. All we want is to get back the payment. And so the greed, the unreasonableness is actually in every single place. But if we need to find the differences, whenever we go different places, I think people will use their own local culture to try to discourage you from doing your way. So that will be a challenge for us when you're in-house, and then you need to sometimes handle things in US, sometimes in Europe and in other places. You really need to travel a lot more in order to say, no, I understand that. Or maybe we need more diversity. Like the panel here, we're so not really diverse. But sometimes we will need to have a more international team. And Hong Kong, I remember PS told me the other day, is in fact a very good bridge. You mentioned about that because we actually understand different things and so on. And so do you think you sometimes in your dispute resolutions, your role is not just a lawyer, but you need to do the translation part, although we have the AI?
I think if I venture beyond the role as lawyer, it would become very dangerous in my experience and actual experience. There was a time which I have to travel outside jurisdiction with my client to have a board meeting with the counterparty to resolve a dispute. And at that occasion, I was essentially the mouthpiece of the client because the two parties, they speak different language. So I have to translate my client's speech to the counterparty. And so I was the mouthpiece. And the counterparty became so angry at my speech because I translate for my client. I got beaten up at the same occasion. I don't mind, actually, but it actually speaks of our role as lawyer. Don't become a mouthpiece for your client. Provide your legal service to client. Advise them what to say, what to do in a litigation or dispute. Do our job. Thank you.
Well, thank you so much for all the sharing. And let's resolve our dispute now because we need to remove that obstacle to everyone's lunch hour. Thanks, everyone, for coming to this session today. And thank you to all of our panelists.
Thank you all. Would our panelists please stay as the Law Society would like to present you a souvenir? May we invite Vice President Chris Yu to come onto the stage and present the souvenirs for us. Chris, please.